Hey, you guys. I'm Ebony Dubois, and I own Credit Repair Vet and members in the medical collection group that I have. And I started this group because a lot of us have medical collections and nobody really focuses on that, yet it's a large part of our lives. And the reason people don't focus on that is because we're always told that no matter what, it won't be held against you. It can't stop you from getting a job. Um, where you live isn't going to take that into account. And that's not really the truth of the matter, though. They don't say they take it into account because that's illegal. But if you have medical concerns and you go to get a job and they run your credit and they see a lot of medical bills, it's human nature to take that into account. It's human nature to sit down and say, oh, well, you're in the hospital all the time. So if you're in the hospital all the time, then you're not going to be at work. But they can't legally say that to you, okay? But I guarantee you, the thought runs across a person's mind because that's what we do at a job interview. We assess each other. You're assessing if you want to work for the company, and they're assessing if you're a good fit for the company. So I just bring that up to say this should be a larger part of the credit repair industry than it is right now. Because regardless of what the law says, we all know that people skate the line all the time with things. Okay. So that part being said, the other thing is say you're moving into a place, okay, and you're disabled or you got into a car accident, now you're in a wheelchair. And by law, that apartment building has to have a wheelchair ramp and everything else, okay? So nowadays we do a lot of stuff online, right? So if we apply for these apartments, these houses, and things like that online, whether we're renting or what have you, they run our credit. And so when they see all these astronomical $200,000 bills, they may even go as far as to think this place is not accessible for somebody with a lot of medical problems. And you might find yourself getting turned away, and all the apartment complex is going to tell you is that they went with someone else or that your credit score wasn't large enough. So I'm giving you these two examples to show you why medical collections should have a bigger part in our lives than it currently has. All right, so I have this set. It's called a lunch and learn because I wanted you to be able to take 30 minutes out of your day, absorb from information, and then go on about your day. Take it in, listen to it right now, listen to it later in your car, listen to it while you do the dishes. Just figure out where does this fit in my life and just go from there, okay? So that's what I want you to do with this information. So if you're on your lunch break and you're listening, great. If you're listening while you're driving home, while you're washing the dishes, just absorb it, okay? Just listen to it, absorb it. If you have questions, my Facebook business page is Credit Repair Vet, VET. I'm a veteran from the U.S. Services, and I'm a veteran at doing credit repair. So message me on Credit Repair Vet. You can private message me there, or you can just post, or you can be in the medical collections group. So it's medical collections plus collections, and you can be added here, okay? So that's not a problem. So let's get started so that I can be a respecter of your time, just like I want people to be a respecter of my time, all right? Because I really do appreciate that. So what I want to cover right now is I kind of want to just talk about what's most important to know outside of the two things we just talked about. This is also important to know. So what's HIPAA? How does it apply? What are the myths out there that's about HIPAA? And what kind of when can medical be sent to collections? And when can it be removed from the credit report? Let's talk about those things because if we don't understand this, then we're never going to understand how to get it off the credit report, okay? So they hand out HIPAA fact sheets at every hospital. They're almost on every website. You can Google HIPAA fact sheets yourself. This is not private information. I didn't draft this up. This is information that's already out there and available. But the skill is, can you find it? The skill is, can you get it? Can you understand it? And can you apply it to your craft and your talent and your skill? And that's what's really important here, okay? All right. So the Health Insurance Portability and Accountability Act of 1996. That's what HIPAA stands for. The Health Insurance Portability and Accountability Act of 1996. You see the date on that? 1996. Today is 2018, okay? It's not that old. So we're just getting around to the point of safeguarding ourselves. And now with the day and age of technology and everything being added to credit reports, it's kind of a little iffy there on how we're going to continue to safeguard ourselves. So let's talk about what the HIPAA Act actually is. Requires health plans, health information clearinghouses, and healthcare providers to conduct certain transactions electronically to ensure individuals' identifiable health information remains confidential and secure. Okay, so health plans. I shouldn't know anything about your coverage. You shouldn't know anything about my coverage. Nobody should have that information, okay? Not even a third party should have that information. How you paid for it. If it was paid for insurance, then it should just say it was paid for insurance. It shouldn't have any health plan information in there. Health information clearinghouses. People who maintain this information. Sometimes people lose information through data breaches, okay? So we have to make sure that this is secure and that it's safe. So healthcare providers that conduct certain transactions electronically. When was the last time you went somewhere and it wasn't electronic? Even now, when you go to the doctor's office, you're given nothing when you leave. When they say, oh, you have a prescription, where would you like us to send it? Think about that. Where would you like us to send? How do you think that's being sent somewhere? They're not faxing it over. They're jumping on their computer before you even leave the doctor's office and they're typing it in. And they say, yes, would you like the Walgreens on? And they tell you the intersection, right? Exactly. So they tell you the intersection, they send it off, and it's gone. And they say, okay, just go to your pharmacy and it'll be there. That is an electronic transfer of information, of your private information somewhere else. That's what this is going to protect you from also, okay? So I want you to understand everything HIPAA is designed to protect you from. Everything should remain confidential and secure. That means you're in charge of your confidentiality. You are. Okay, so let's talk about some HIPAA myths. I need you to understand the myths so you can understand what you can go after and what you can't go after so that you can have a conversation with your client like you have some common sense, because that's what it is. The more you talk to your client like you have some know-it, the more they're going to understand, comprehend that, wow, this person knows what they're talking about. I'm going to feel really confident and I'm going to trust you. And that's how it's going to happen, okay? So I want to share that with you. All right. So HIPAA myths and facts, okay? Patients can take healthcare providers to court for a HIPAA privacy violation. I want you to receive that, because a lot of people in the credit field feel like, oh, they didn't take it off, I'm going to sue them. That's not how HIPAA works. So when you go to court for credit repair errors, you're going for something that was harmful. And to be harmful, it means it has to prevent you from getting a house, prevent you from moving forward, prevent you from getting the job of your dreams. It had to harm you financially. It had to be harmful to you in a way that injured your family. It had to be injurious. That is the definition of what we can take people to court for in credit repair. Was it injurious? A privacy violation may or may not be injurious, but if you're taking it to the credit bureau for them not removing it, it can be injurious. If you're trying to take the healthcare provider for a privacy violation, no, they did not intend to injure you. They did not stop you from getting a house. That was the credit bureau who refused to remove it from your report. That was the credit bureau who cost you that job because they reported something that clearly said medical. You see it right at the top. It says medical. And that's crazy that you can just put medical up there, but you're not allowed to share my confidential information. But now someone knows something medical is going on because you put the words medical there. That is not allowed. All right. So here's the actual answer. They cannot take a medical provider to court. The fact is, even if the healthcare provider commits the worst kind of privacy violation, the affected individual may only complain to the Secretary of Health and Human Services, HSS. Appropriate investigations and subsequent penalties, if levied, will be imposed by the HSS and will be enforced by Department of Justice. So I want you to receive that. You can file complaints and they may or may not be penalized. But if they're penalized, it's enforced by the Department of Justice. It's not enforced by the Credit Bureau. It's not enforced by FACTA. It's not enforced by the FTC. Yes, this is a credit issue because your client has debt on their credit report for medical, but you cannot sue the provider. So I just need you to receive that and understand that. So when they say, oh, I'm going to sue the doctor's office, some pump your brakes a little bit. That's not the way we're going to do it today, okay? All right, so the second myth I want to talk about. Healthcare providers are allowed to share personal information about patients with their employers. I'm guessing you're thinking about that answer right now, right? Healthcare providers, your doctor, your urgent care, the ER, they're allowed to share your information with your employer. They are not. Employers are not allowed to get access to personal health information about patients who are their employees, but only with the consent of the patient. So don't walk into your job and sign away your medical and give them consent. Now, there are times where they stipulate they have to have access, like if your job pays for you to go to therapy. A lot of the time, they have you waive your HIPAA rights to that because they want to be able to talk to the therapist. And I want you to be aware that that's what's happening. They want to talk to the therapist, so they have you sign your HIPAA rights saying you're going to see a company therapist, they're going to pay for it, and then they're going to be able to talk to the therapist about if you're mentally sound. So this is the same thing. So be aware of that, okay? So this cannot be done without your explicit written consent. And that's what I'm talking about. You have to sign the paperwork. So details about information to be shared. It even asks you on the form, what do you want to share? Do you want to share lab results, test results? Do you want to share x-rays? And you have to check the box, or at the bottom, there's a disclaimer that you want the entire file shared. And most people are lazy. So they check for the entire file to be shared. And you don't even realize how thick your file is and how far your file goes back, okay? So I want you to keep that in mind, okay? But it has to be signed and endorsed by you. So please bear that in mind. Can you guarantee removal of medical off the credit report? Not as a credit repair company, you cannot guarantee it, but you can get pretty dang on close, okay? So as a credit repair company, you can tell them there are ways that will remove it off their credit report, but you cannot promise or guarantee that, okay? So don't throw out 100% number. I really just like when I hear credit repair companies do that. I got a way that's 100%. Okay, I'm successful at getting medical records off also. And I might tell you the last 4 cases that I did, the last 4 reports that I attacked, I was 100% successful with those 4. But I'm not allowed to legally tell you that I'm going to guarantee you I got it off. Don't worry about it. I got it. Be mindful of what you say. That is why we have a license. That is why we are bonded. Because somebody may very well take us. Have to be careful. This is our business. This is our livelihood, you guys. This is not a hobby. This is not something we do on the side. If you have a 9-to-5, you don't want a hobby that you can get a lawsuit behind. You don't want a hobby that somebody can take your livelihood from you, where they can sue you and win your house because you own property, or because you list your car as a company asset and your company just lost in court. So when I tell you, this is not a hobby to play lightly with. You're bonded and you're licensed for a reason. It's because we're in danger. So I need you to be decent and in order when you move forward. Be knowledgeable, okay? And how can I say that this could come off? A lot of the time, 85 to 100% of the time, it's off in the first 30 days that I work the file. But I need you to understand that I can give a percentage of my success rate with prior people. And that's all I'm doing. I'm giving a percentage of my success rate with prior clients. So keep that in mind for me, okay? And we're going to circle back to that. All right, so HIPAA. The patient's family member is not allowed to pick up prescriptions and other documents related to the patient. Some of you have kids. Some of you have been to CVS, Walgreens, Walmart. You've been to the pharmacy. So you already know the truth about this. You know that you can pick it up. You can pick up documents. You can pick up x-rays. You can pick up other medical records that can be picked up by the patient's family member. And when you go to the pharmacy, they can sell the prescription to any person other than the patient. You don't have to be related at the pharmacy. You don't have to have any relation at all. So I want you to receive that, because this could account for some of those bills. Medicines add up, okay? And if you're claiming you never got them, you claiming they were stolen, someone else picked it up, whatever the client is claiming, I need you to understand and realize that the pharmacist will sell that prescription to anybody. So if it's digitally sent and it's there, do they check IDs? Yeah, sometimes. But most of the time when I go to the pharmacist, they say, what's the patient's name and what's the patient's date of birth? What's the address of the patient? And that's it. Or they might say, what's your relationship? And then they say, sign here. That's how they do it here in California a lot of the time. So be wary of that, okay? All right. Healthcare providers cannot share information about the patient with the patient's family without written permission. So you go to the hospital, your family comes in a room with you. Do you stop and write down and tell the doctor it's okay to share it with them? Or do the doctor just start talking and the doctor goes, is this okay? And you just look up and head nod. Or you say, and then the doctor says, can you give me a minute? So let's talk about what's supposed to happen. It's not so that it has to be written. When the situation warrants it, the patient's family or close friends or associates, you may not even know them that well. It might be the person who drove you to the hospital, the person who drove you to urgent care, the person who drove you there, helped you get there, helped you fill out the form. They will be given information about the patient's health condition, insurance, payments, without anything in writing. So if I walked into the doctor's office with you and we were just talking at the bus stop and they think I'm with you, they may come out and give me an update. And if I'm nosy Susie Q, I'm going to sit there and listen and be like, what happened? Oh my goodness, she had a stroke. What? She had heat exhaustion? What? Oh, well, I don't know. We just met and just talked. And then the nurse is like, oh my goodness. And you're all like, it's okay. But they're not going to get a lawsuit behind that. They saw you with that person. You were talking to that person. They went out to the waiting room and talked to that person. So I just want you to understand that's a little extreme. But I want you to understand and to really get what I'm saying to you right here about HIPAA. There's so much you need to understand when you're talking to your client and they're describing their medical situation. And you just have to let them know, okay, well, you can't sue them behind this, or go see a lawyer and let the lawyer tell them they can't sue them. But I'm telling you not to waste your time. I'm telling you that your time is valuable and you need to walk away from it if that's the direction they want to go in, okay? Because you can't take that to court, not if they're going after the medical provider. Now, if we want to talk about the credit bureau, then let's talk about the credit bureau. All right. Last HIPAA myth and fact: patients' medical records cannot be used for marketing. And you might be wondering, why is this important? Because we're talking about third parties when it comes to credit report. And I want you to understand, this kind of looks that way, doesn't it? Patients' medical records cannot be used for marketing. Does that not sound like third-party activity written all over it? And that's what we're talking about with credit repair, right? Third-party information. All right. So here's the deal with that, okay? It is not a violation. This is one of the most popular myths surrounding the HIPAA, okay? Making a patient know about the details of certain health and insurance plans is not considered marketing. So here's what the hospital does, or the urgent care, wherever you at. They may get on the phone and start making some phone calls. So when the doctor tells you we're looking for something, we're trying to find something that'll help you, they're making phone calls and talking about your situation. They're talking about your business with outside resources. But that's not a violation. Are they marketing? Yes, they're marketing your condition, they're marketing your situation, your health, your status, because they're trying to find something that fits your insurance. They're trying to find something that fits you, but they're also giving away your information, okay? So all those companies they're calling now has your information. So now you might start getting mail at your home address. And as you're getting mail at your home address, you're like, where'd this come from? How did they know I was in the hospital? Who told my business? The hospital told your business. The hospital told all these pharmaceutical companies that you needed a particular medication while they were calling around trying to see if they can get you approved for the brand name or if they can get you approved for the off brand. They managed to get you approved for something, but now everybody knows your business. So I want you to receive that, okay? So all that mail you're getting, the surveys for, do you have somebody with diabetes in your house? Does somebody have this kind of medication? And did they get the mesh and everything else that they write you about and tell you, okay? And you're looking at your mail. It came from the hospital. And no, you're not going to win a lawsuit against them because all intents and purposes, they were protected under HIPAA trying to help you. So I just want you to receive these facts and myths that I've discussed with you so that you can be knowledgeable when you talk to your clients, okay? Please believe and receive that. All right. So how do you safeguard your information? So this is a letter that I like to use. I call it a change to opt out of sharing with third parties. So this is what I send to the hospital. This helps you with getting the collection removed, all right? Now I want you to also understand this, okay? As I say it. You need to send this to the hospital in question. It needs to go to the urgent care in question. It needs to go to the medical service provider. This is for the medical service provider. I'm saying that again because you're going to say, does this go to the credit bureau? No. You're going to say, does this go to the collections place? No. This needs to go to the hospital, to ER, to urgent care, to the doctor's office, wherever you sought medical attention. This is for them. You just call them on the phone. You say, hey, I was there and I'll need to change my records. I allow someone to have permission. That's a third party. And I'd like to change my HIPAA requirements. A lot of the time they'll send you to risk management. They'll have a department, or they'll call it records because records keeps your records, right? Or they'll send you to admission because admission gives you your first HIPAA form when you arrive. So when you call, they may send you to any of those three places. So please receive risk management or records or admissions. They typically don't have a HIPAA department. They do have a business office. That business office may have your records also, okay? So be flexible when you call the hospital. Ask them for their fax number. And then you send this fax to them. And what does it say? It says, I'm listing my name, the number of my account. My account numbers are here. Medical and the center's name. So you're going to put today's date, the medical center's name, the medical center's address, attention, HIPAA department, change to opt out of sharing with third party. You can't get more clear than that, right? What is it she wants? What is it he wants me to do? Do not share my information with third parties. So read these accounts. Often you have medical bills with different account numbers, right? Because sometimes if you're a parent, you've got your account numbers, you've got your kids' account numbers, and even their stuff will hit your credit report. So you have to safeguard that, okay? You list the account numbers, however many there are that pertain to that hospital, because you want to make sure that every account is locked up tight at that hospital. I am asserting my rights under Financial Services Modernization Act and the Fair Credit Reporting Act to opt out of the following two uses of my personal information. A, you do not have permission to disclose personally identify information with your non-affiliated third-party companies or individuals. B, you do not have permission to disclose my creditworthiness to any affiliate. So what did I just say? Let's put that in English. I'm telling urgent care, ER, the doctor's office, my medical service provider, you do not have the right to share my information. And the reason it says Financial Services Modernization Act, because I'm limiting what you can say about my income, about what you can say about the bill, about what you can put out there, because that's what credit bureaus report, right? They report debt to income ratio. They report how much the debt is, when the debt occurred, how long the debt's going to stay there. So it's very vital that we include this information. It's really, really important, okay? And I'll do another one to go into more detail on that, but I really want to give you an overview and not take up all your time. Remember, this is a lunch and learn, right? And I want to be a respecter of your time. So the second part says, I am further instructing you, do not disclose any of my transaction and experience information to any affiliate of yours. Do not disclose any information about me in connection with marketing agreements between you and other companies. There it is. Do not talk about my transactions. So once you serve them with this, say you made a $5 payment. Now the credit bureau is $5 off, right? So after you update this, the credit bureau contacts the hospital, or they contact the collection place. The collection place tries to contact the hospital and they say, oh, we've updated the HIPAA agreement. We can no longer talk to you about this. I'm going to let you absorb that for a second. We've updated the HIPAA agreement. We can no longer talk to you about this. So can they answer the credit bureau within 30 days? No, because you just told them your finances were off limits, your transactions were off limits. So they cannot update. And if they can't update, then FCRA says they are out of bounds. This is why medical is so important. There are a lot of rules and technicalities, but we got to know where we fit in, okay? The last paragraph on here says, please respond to me in writing stating that you will comply with these instructions. If I have not received a letter within 30 days, I always change that to 10. Within 30 days, specifically denying my instructions, I will assume your records have been noted to comply with this letter. I am mailing this in a sealed envelope, and I am not including my social security number. I believe my name, address, and account number identify me sufficiently. Client's name and the date. Don't sign it. Just print the name. As long as you have your power of attorney. As a credit repair company, you should have your power of attorney. Okay? So, again, what I'm saying right there is they need to write me back. And I like to change that 30 days into 10 because there's nothing that says they need 30 days. There's nothing in writing for that. So I change it to 10 often. And most of the time they don't write you back, but they do update it, which is why I'm very successful in the first 30 days, right? Because I send this off, I wait 10, 15 days, I then send to the credit bureau. The credit bureau can't confirm. Boom, shabam, it's gone. It's that simple, okay? But I needed you to understand it. All right. So I had wrote down a couple of questions on here. That's a poll, right? And so I just wanted to go over this really quickly. All right. So when can medical collections be sent to collections? When can medical be sent to collections? Sorry. A, as soon as you leave the ER, urgent care, the doctor, like as soon as you walk out, oh, they already know. They're not going to pay me. I'm sending them to collections today. Do you think it's A? Do you think it's 3 months? So 3 months later, after you default on the payment, can they send you to collections? That's B. Do you think it's B? Okay, C is 6 months after you default on payment. Is 6 months sufficient? And then D is none of the above. Ask yourself, do you think the answer is none of the above? I'm going to tell you the answer is 6 months after you default on payment. So that being said, 6 months after you default on payment, so 6 months after you default on payment, they can send it to the credit bureau, okay? Now they come to the credit repair place and we have to find the fault. The fault is they can't talk about treatment. The fault is they can't talk about diagnosis. The fault is they can't give up any valuable information. They can't have in big words at the top, medical. They can't do that. So I need you to understand that 6 months after default is getting sent to collections. Can you get them out of collections? Yes. Can you get them out and they go back? Say they make a payment arrangement or they start paying the bill. Once you start paying the bill, you make a payment arrangement, it cannot be in collections. It's a violation. It's a violation of HIPAA. It's a violation of everything because the FCRA is going to be out of balance every day, right? The balance is going to be changing and it's not going to meet the guidelines. So I need you to receive that. So I'm just giving you some pause right there so that you can receive that because I talk a mile a minute and I'm aware of the fact that I talk really fast, okay? But I do want to, like I said, be a respecter of time. So I'm going to close out shortly. I think we got 3 slides left and that's it. So 6 months. So if you pull them out and they start making payments and then they stop making payments, 6 months from when they stop making payments, it's going back into collections. So say you're struggling and they're trying to buy a house. Say they pay it, it comes off, and then they buy their house and later it goes back. And you can just ask them, well, did you stop paying it? And they'll just say, yes. Okay, well, that's why it went back. Now we're going to fight it again because we're sure there's a violation there somewhere. But I just need you to be upfront with people. Do you trying to buy yourself 6 months? Start make a payment arrangement. Start making payments. You can buy yourself 6 months from the time you stop making payments, and then it'll go back on your credit report. I just like to give people all the information and be as honest as possible, as I want people to be honest with me. I ask my clients who have $200,000 bills or $20,000 bills. I have those kind of medical bills. So I want to just be honest and say, can you pay this? Is that an option for us? Because that's our number one question when we get charge-offs and collections. Are we in a position to settle, pay per delete? What are we in a position to do? And they'll tell you, never finna pay that medical bill. I can't do that. I got to feed my kids. They'll tell you whatever and just roll with that. It's not about judging people. It's just about that, okay? All right. So there was one more poll. So the last poll that I have is when can it be removed from the credit report? A, never. B, whenever you want. C, the day that it's added. Or D, after it's paid in full. So is the answer A for never? When can it be removed off the credit report? B, whenever you want. I feel like it's Sunday. I want it taken off. Or Tuesday, it was added. Well, it's Tuesday, it was added. I want it taken off right now. Or D, after it's paid in full. Okay, so technically, if you find a violation, you can get it off as soon as you find a violation. A violation with the FCRA, a violation with HIPAA, a violation with the financial part of it that we talked about earlier, the Financial Modernization Act. If you find a violation, it's gone, okay? After it's paid in full, definitely it's gone, okay? So the correct answer is here is D, after it's paid in full. So the only real answers are after paid in full or if you find a violation. Then it has to be removed, okay? Those are the answers. And if you're asking yourself, where did I find this information at? I looked on mentorhealth.com for HIPAA myths and facts. I've been to the modernization websites for the Financial Modernization Act. I've been on the FCRA, but this is just a short little clip that I wanted to talk to you about so that you have some background on what it takes to get it off. So now I hope I provided you with some value. I hope that I've given you something where you'll listen to it later and go, okay, what did she say I could use? And I gave you a lot of background information because I do believe that knowledge is power, but you know what's more powerful? Proper application. That is more powerful than knowledge. Proper application, okay? So please receive this. Again, I'm Ebony Dubois. I own Credit Repair Vet. I have a Facebook page called Credit Repair Vet, VET. I have this medical collections group, and I'm happy to share this video. I don't mind if you share the video with other people. I want us to grow. I want us to develop each other, and that's what I want, okay? I just want to further us. I want to take care of us in the community, take care of us in the home, and just grow us from there. And by us, I mean all of us, okay? It's not a race thing. It's not a gender thing. It's we in trouble. We got some medical concerns and we need some help, whether it's the client or your family. And that's the goal. So I did my best to hold to time. I hope that I did all right for you. It's 35 minutes in, so a little bit over. But you understand this topic, it needs to be broken up into a series. So I hope to see you next week. And next week, I'll tackle a little bit more past the HIPAA letter. And what do you send after you send the HIPAA letter? What letter do I send to the collections? Come back next week and let's talk about that, okay? All right. Thank you so much for coming. Thank you so much for being a part of the class today. I really do appreciate that. And I appreciate you so much. All right. Have a great day.